You're all for the requirement of a warrant to support a constitutional search or seizure in the absence of a generally recognized exception to the warrant requirement. Is that correct?
Yes.
You're all in favor of requiring probable cause to support the issuance of a warrant permitting a particularized search and seizure, isn't that so?
Yes.
So what's new?
The technology is new. The technology that we're using to make these searches today is new. Hannah mentioned the case Kylo v. U.S. Thermal imaging devices were not around when the Fourth Amendment was written, and these new technologies are what is new, and that's why we need to adapt the Fourth Amendment to protect ourselves from these new technologies that are more invasive.
And how do you do that? For instance, emails. You're a student at a public university, and it's supported with government money. Do you give up your right to privacy in that context? When you're taking government money and you have email, can the government come in and look and see what you have been emailing other people without a warrant?
I would say that in that case you have very little expectation of privacy, so yes, I would say that would be okay.
Why?
Well, I think that you would have no expectation of privacy because since the government...
Sorry, did you say less expectation?
Yes, I said less. Yeah, I think that because if it is a email issued by, let's say, the university, then you are using their money. They're providing you with the email, so I think they should have the right that if they need to, they can look into your emails because they are providing you with that service.
I have to disagree with my friends and say that no, that you have an expectation of privacy with your email. To me, an email is still a letter, as ruled in Ex parte Jackson. The government cannot open your letters, and to me, email is just another form of a letter, just delivered electronically.
At the same time, letters that Laura mentioning, physical mail is operated by a government service, and email is run by private companies. So although you might not have an expectation of privacy from the private company, I feel that, though this is really ruled null and void under the Patriot Act, I feel that your email should be more private.
Because the Patriot, I'm sorry.
Do we take the same position with respect to Facebook profiles?
I do not. Facebook profiles is more of a public forum, and it's a place where you are putting information about yourself out into a public chat room. To me, it's very similar as sitting in a park and talking with your friends.
Does the development of thermal imaging technology alter, as a matter of law, what an objectively reasonable expectation of privacy is?
Could you repeat the question, please?
Yes. Does the development of thermal imaging technology, which I believe Ms. Rosnowski alluded to earlier, alter, as a matter of constitutional law, what constitutes a reasonably objective expectation of privacy?
Well, I would cite Justice Harlan, who wrote in Katz v. U.S. in his concurrence that electronic, and in this case thermal imaging, as well as physical intrusion into a place that is, in this sense, private, may constitute a violation of the Fourth Amendment. So whatever the means of intrusion be, I feel that whether it's technology or physical intrusion, I think you still have the same expectation of privacy in the place, regardless of the methods being used to access the information.
Similarly, in U.S. v. Dunn, which is the case involving whether or not a barn could be searched and whether or not the barn was within the curtilage of the residence, the court spoke of the umbrella of the Fourth Amendment and what was protected in regards of the home and included in that. And in terms of thermal imaging, the question arises, is what leaves your house able to be searched without a warrant, or is that still part of your home and your residence and therefore your privacy?
So a search of a barn via thermal imaging technology constitutes a search in the constitutional sense. Is that so?
Yes.
All right. If that's so, is the issuance of a warrant required before that thermal imaging technology can be used to engage in the search?
I don't think it should be. Justice Stevens said that the heat waves emanating from your house are very similar to those walking from a kitchen or a meth lab. And if you smell a meth lab, you're going to go and bust that meth lab. So to me, it's very similar.
However, the court did rule in Kylo v. U.S. that you would require a warrant to be able to measure the heat waves with a thermal imaging device. Though I do disagree. I would disagree with Angie and feel that that is not a search. The heat is merely, as Laura said, emanating from your house, and anyone who walks by should be able in a reasonable way to somehow sense that, and just enhancing your sensory facilities bestowed to you at birth is not unconstitutional, I believe.
So the use of thermal imaging is simply an enhanced form of open view, which doesn't constitute a search. Is that what you're saying?
Yes.
Let me change context. Suppose that I'm law enforcement and that I have applied for a search warrant to search your computer for certain financial information on your computer and in the context of drug sales, okay? And while I'm searching your computer, I come across pornography and charge the defendant with pornography. Is that legal? Is that a legal search?
I think that that situation would fall under the doctrine of inevitable discovery as established in Nix v. Williams. And because you were searching the computer for specific files, if you found something else illegal, there's no reason that you shouldn't be able to prosecute the person under that as well.